Chief, Chief Dry Geese Territory. From time immemorial, it has been the traditional land of the Yellowknives Dene First Nation, and more recently, the homeland of the North Slave Métis Alliance. We respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. Many thanks to Laura Farina, head of the CBA Northwest Territories section on immigration law, among others, for organizing this very topical and critical conversation today dealing with the intersection of criminal, family, and immigration law. Also, we're very grateful to our presenters for making the time to join us today. Thank you. So today we will hear from Cheryl Robinson and BJ Caruso on overlaps with family law, and then BJ and Connie Campbell on overlaps with criminal law. There will be a short question period at the end. Cheryl is a staff lawyer with Legal Aid Ontario, who regularly appears before all levels of the Immigration and Refugee Board and the Federal Court, and speaks at seminars and conferences. BJ is the founder of corporate immigration law firm Professional Corporation. She has practiced immigration law for over 25 years and is the co-author of 2 leading textbooks published by Carswell. Connie practices at Edelmann and Company and in all areas of immigration and refugee law. She has experience before the Immigration and Refugee Board, the Federal Court of Canada, the BC Supreme Court, and the BC Court of Appeal. I invite you to read their full biographies linked to the event post. I'll ask Cheryl to hand off to BJ and BJ to Connie once each of you is done your bit. We've been very much looking forward to this session. And so thanks again for your time and everybody for participating. And Cheryl, please start us off.
Thank you, Mark. So I have a brief PowerPoint that I'm just going to share. It's really just to highlight some of the core issues that I see in my practice and things that are important to know. As Mark said, I'm going to be really focusing on that issue of intersection between family and immigration law and leaving the criminal side for BJ and Connie to address. Really, I thought that the best thing to start off with is to acknowledge upfront that family law and immigration law interactions are often very factually specific. That it's not as clear cut in terms of this will happen, this will impact your proceedings. It's a lot of variation depending on your client's immigration status. So I thought I'd outline some best practices and issues to consider in terms of this practice. And so starting off with that best practices, this is something that goes also for the criminal side. But the first thing is always to make sure that you know the immigration status of your clients. And that includes any minors. And that's because different members of a family can hold different Canadian immigration statuses. They can even have different citizenships or nationalities, and this will have implications for any proceedings. And that it's really important really to know whether the person holds a permanent or a temporary status, or even if they're a refugee claimant or refugee. And coordinated with that, you also need to know if there is an immigration status at play. You need to know the past immigration history. So any previous applications, if there's any interactions with either IRCC or CBSA. So those are the two, the CBSA is the enforcement agency and IRCC are the decision-making group in terms of who gets to come into Canada and stay. And also the last one is if there are any removal proceedings, and that's because anyone who is not a Canadian citizen may end up with removal proceedings at some point. And you need to be aware of this. And the last thing, and this is, for anyone who practices family law, I'm sure this is certainly something you already know, but where there are minors, it's really important to identify who holds that decision-making authority, because that impacts on the immigration proceedings, as well as impacting on what potential family law proceedings can go ahead. And the last pitch is always to reach out to your friendly immigration counsel if you're concerned that immigration statuses are an issue, or if you need clarification as to what the status is that the person holds and the impact. So why do we actually need to know all this information? Why is it important? And simply, when we, simply put, a person's immigration status can change the course of family proceedings. And that includes what steps or what evidence needs to be presented to protect the interests of your clients. And it can even impact which parties are going to participate in family law proceedings. And in that, I'm generally also including child protection proceedings, because in my practice, this is often where I see a huge impact. So I thought that I would sort of discuss a couple of different places where immigration status has an impact on how family proceedings, how they proceed, and then also substantively the impact. So one of the areas is where you have applications to return a child. And so, for example, this is actually an area where there's a lot of impact. It's one of the types of cases where my work as an immigration lawyer has significant overlap with family law side cases. And we see these arising where, there's a parent who's brought their kid or kids to Canada, and there's a left behind parent in the country of nationality. And it can raise issues of whether the parent had consent to bring the children to Canada. And there can be allegations of child abduction or child retention, which is dealt with in family court proceedings by way of application to have the child return to the left behind parent in their country of citizenship. And this, engages the Hague Convention on Child Abduction or the Family Law Act in the territories. And in this circumstance, it is actually incredibly important to know the immigration status of the parent here in Canada and the minors, and that specifically when it comes to risk assessments, like refugee or PRAS, that status has the ability to really have an effect on the whole procedure and also the merits of one of these types of applications. And I've just cited to a couple of cases. They're mostly cases, obviously, that are in the Ontario courts. I had a quick look. I couldn't see anything in Northwest Territory, but I'll note that there's a lot of these cases across the country that reflect a lot of the similar considerations, which is that, if there is an outstanding refugee claim for a minor, that it does become a factor as to whether the return order proceedings need to be paused in order to allow the refugee claim process to be finalized. And that's a lot to do with the Section 7 rights at risk in a refugee claim. And it impacts the procedure. So can the court issue a return order to that left behind parent in the country of nationality where there's an outstanding refugee claim? And it also has an impact on what evidence a family lawyer would be able to disclose to the court. The court needs to become aware of this refugee claim or risk assessment, and they need to know whether there's a final determination that is imminent. But at the same time, the refugee claim and the immigration materials should be protected and not disclosed because it's a confidential proceeding. The refugee claim process is a confidential proceeding at the board. And then we also see an effect on the merits of such a claim, because there is case law, and I've provided the one that's leading in Ontario, but there's case law that shows that if there's a positive refugee claim, meaning that someone has been found at risk and returned to their country of nationality, that it actually creates this rebuttable presumption of risk under the Hague Convention, which impacts whether that child can be returned. And so I know this starts off on more unusual proceedings in the family courts, but immigration status also has impact upon a more regular, proceeding about decision-making authority over a child. So, what, as an immigration lawyer, I still refer to as custody and access. And, immigration status, permanent or temporary, can become relevant to the consideration of best interests of the child. Is this something, does the child have the ability to stay here? Is that going to impact their ability to enroll in school? And what is in their best interests in those circumstances? And the other issue is, as I mentioned before, removal proceedings can always occur. someone can be subject to a removal order if they're not a citizen. And that's something that is also, if you know that your individual has an immigration status, and this includes permanent residence, there needs to be that clarification as to whether there is any interaction with immigration or CBSA in terms of potential removal proceedings. Because one of the things that comes up repeatedly in the sort of clash between family and immigration is that immigration, when there is a removal order, there's a mandate to remove a person as soon as possible. But a family court order around custody, even a non-removal order issued by a family court, doesn't actually stop that removal mechanism in immigration. So this is because, the Immigration and Refugee Protection Act defines that CBSA is the body that determines, it removes people, and, who decides who gets to stay in Canada and who has to leave is under the jurisdiction of immigration authorities. So this is something that has come up in my practice as well, that there's custody orders which give custody of a child or decision-making authority and residence of the child to the parent who is here in Canada. But that does not automatically mean that they have to stay in Canada and that any removal under immigration is stopped. And we see this playing out in terms of, and I've given the provision, but really the broad strokes are that, it's immigration that decides whether a removal proceeding goes ahead, even if there is a custody order or a non-removal order issued by the family courts. And that's a lot to do with, as it said, the provision in the Act, which requires that the minister gets to weigh in on this issue on whether someone should be removed. And so I've just provided one of the cases where this has become an issue. Are the slides not advancing? Sorry, I just saw oh, it's
Yeah, we can see
not.
them now. Yeah.
Oh, okay. Yeah. Sorry. Okay, and so the last thing I wanted to talk about is the penultimate thing rather is really just that there is also impact in child protection proceedings. Again, you need to know the immigration status of the child, because if a child has been apprehended and is in the care of child services, this doesn't automatically mean that they can't be removed from Canada. The question of whether they can stay often comes down to whether the minister has the opportunity to make submissions, whether there's a removal interest that has to be prioritized. And this is all a matter that's actually not decided by the family courts. It's again decided by the federal courts that has jurisdiction over removal and immigration. And as I mentioned before, this actually, if there is a child protection proceeding, this may mean that the Minister of Public Safety and Emergency Preparedness is actually a party to the child protection proceedings, which is unusual. And that's there's some case law about what that means in terms of context, but there is a possibility that the minister has the ability to make submissions and can be given disclosure from child protection proceedings, which is unusual because obviously child protection proceedings are usually confidential. But any of that would have to be ordered by the court in terms of disclosure. And so that's something when you're looking at best practices, you have to make sure that if you're a client, and that's the child or adult, has interaction with CBSA, that they're aware that you are aware of any requests being made by CBSA for confidential materials. And you need to discuss that with Immigration Counsel as to whether you can comply with that. And that it's really important to have that, to liaise with Immigration Counsel and to make sure that you are aware of any outstanding applications that would be relevant to either family or child protection proceedings. And the last thing that I wanted to cover was really just that, again, following up on this issue of child protection for minors who have been in protective care, for minors who came to Canada under the age of 19, who were under the legal responsibility at that time of a child and family services provider, and who never obtained either permanent or resident status, or perhaps even obtained and lost it, there is actually now a permanent residence pathway for former minors in protective care. It's based on a temporary public policy, and it's, sorry, that should say 2027. It's open until January 21st, 2027. And it is a way to obtain either permanent residence and temporary residence while the permanent residence application is being considered. And so again, this is where immigration status becomes very important, because I do work with a number of minors who, for whatever reason, minors and those that have passed the age of 19, that never obtained status, even though they were in care. And this is a new public policy that would help them obtain status. So that is all I was going to cover. As I said, it's a very factually specific interaction in terms of impact. And so I'm just looking at the question. Refugee proceedings are confidential. Is the mere disclosure of the existence of a claim in family law materials a breach of that confidentiality? Are there limits to what can or cannot be disclosed regarding immigration proceedings in family or child protection hearings? Is the disclosure of the name a child a breach? So just turning to that first one, yes, refugee proceedings are confidential. The IRPA 166C says that these are to be conducted in the absence of the public. And that has effectively translated into a situation where a refugee claim materials are not supposed to be disclosed because they are covered by that confidentiality. There are certainly limits. My perspective is that none of the materials underlying that refugee claim can be disclosed into family or child protection hearings. So basis of claim, any of the evidence that's being provided, that should not go, refugee proceeding materials that should not go into the family or child protection proceedings. I have, when I've worked with family law or child protection counsel, I have provided letters confirming the existence of a refugee claim for the individual, but no further detail. It really is meant to be confidential. And part of this is really a matter of protection. It's to protect the refugee claimants from any retaliation. And this actually comes up. I have a lot of cases where the person who is named as being the agent of persecution because of abuse or domestic violence is also here in Canada. And so disclosing the contents of a refugee claim can actually create an increased risk. And so that's something to always be aware of, and particularly because at the Refugee Board, you can actually get a sealing order to even more close off any disclosure of the materials. I wouldn't say disclosure of the name of the child is a breach if they're a claimant, but any further than that, I would say is a breach of that confidentiality. So unless there are any further questions, and I will send those slides out, unless there are any further questions, I am going to turn over to BJ, who's going to pick up on this issue of other interactions with family law.
Great, thanks very much. So I wanted to just give a shout out to Laura and thank her for the invitation. The Northwest Territories actually holds a sort of special place in my legal career because I spent 4 months clerking with the Supreme Court of the Northwest Territories in 1991. So now I'm really dating myself. But it remains to this day probably one of the highlights of my legal career. And I was fortunate to travel all the way west to Tuck. And at the time, Arctic Bay was still part of the Northwest Territories. So anyhow, I saw firsthand how criminal and family law are very much front and center to the legal community up north. And it's not surprising now that immigration is intersecting because your communities are changing and you're seeing more immigrants. So I'm going to touch both on family and criminal. I'm sort of squeezed in the middle because my practice is very much a solicitor's practice. I don't appear in court, and I am helping newcomers and people in Canada file applications with the Immigration Department. So that could be work permits, study permits, permanent resident applications, and spousal sponsorship. So I've picked a few key areas or examples that intersect for discussion. The first is sort of to understand that in the context of immigration, it's not just the applicant, the primary applicant on an application that is being considered. The department under the statute looks at the whole family. And so if the primary applicant is inadmissible for criminal reasons or medical or security, it can impact everybody in that immediate family. So, it is sort of important to understand the definitions of a family under the immigration legislation. So, a spouse includes someone that is legally married spouses, but it also includes a common law, which is cohabitating in a conjugal relationship for at least 1 year. And sometimes we have to gather a lot of different documents to piece together common law evidence, and all for the purposes of sponsoring. So when a Canadian gets to sponsor a spouse, it also includes the conjugal spouse. So this would be someone that is residing outside of Canada who's in a conjugal relationship with the Canadian sponsor for a period of at least 1 year. This is usually tougher to prove, and the focus is usually on their financial circumstances and how intertwined they are, and that the relationship is exclusive. A dependent child, is one that is under the age of 22. And it can also include a child that is over the age of 22 if they've been substantively dependent financially on their parent since obtaining the age of 22. And that financial dependency is due to a physical or medical condition. So the common issues that arise in my practice or that I see routinely that intersect with family include the situation where a sponsor, uh, individual spouse being sponsored may have been married previously and obtained a divorce in a foreign jurisdiction. In that instance, it's routine then for us as immigration counsel to be reviewing the file and making sure that the couple are in fact legally married. And in order to legally marry in Canada and get a marriage license, they'll need an opinion from a Canadian family lawyer attesting to the divorce being legally granted in the foreign jurisdiction. So that's one instance where we'll often interact with family law counsel. I had a very unpleasant experience once of being contacted by the immigration department and informed that my clients weren't legally married. And then I had to relay that news to them. I had to pick up the phone and call them and tell them, hey, by the way, you're not married. In that instance, they had been married in Chile, and it had just been a religious ceremony, and they had not gone through a civil ceremony in Chile. So it made the marriage not legal in that jurisdiction. Immigration picked up on it, and my client had to run to the city hall and get a license and have a civil service in Canada. Those were back in the day when the department would actually keep the file open for you. Now they'll just slam it shut and return it to us. So it's something that we as immigration lawyers take a look at, and sometimes we have to interact with family counsel to assist. There's also an obligation to advise the immigration department if there's a change in marital status. So when a couple separates, this can have an impact then on marital status. And in Canada, there's not legal separation isn't sort of a recognized legal status. You're either single, you're married, or you're divorced. So if the individual who you're representing on an immigration case wants to sort of sever their now separated spouse from the application, it's not so easy to do. Um, we need to provide evidence that they're no longer living together, which sometimes for family uh, law reasons they might continue to live under the same house and roof. And the reason that immigration won't easily sort of accept the applicant's word that, hey, I'm no longer with this person, is because they believe in there's an opportunity for reconciliation. And as long as there's an opportunity for reconciliation, then they may need to be included. The spouse may continue to need to be included in the application and be examined for criminal, medical, and security reasons. So immigration will push back to immigration lawyers like myself saying, we want proof. We want a divorce certificate or something to show that that is in progress, or a custody order, or a separation agreement. So again, this is where we might insist that our clients speak to a family law lawyer to help out, and the family law lawyer may not appreciate why an immigration lawyer is asking for this and why it's important to immigration, but hopefully that helps you to understand that the immigration department um, it needs to examine everyone who is a family member, and as long as they're still legally married and not divorced, the presumption is that they're being included in the application and need to be examined. Um, Third common family situation, which again sort of is similar to the last one, is the issue of custody of children. And so the most typical scenario we see is where one of the parents immigrates to Canada, but they leave behind their minor children or their children under the age of 22 that are still considered dependents under the Immigration Act. And they need to be examined, even though they're not accompanying. And the reason is that if the parent that is in Canada becomes a permanent resident, they'll have the ability to sponsor that child up until that child's 22nd birthday. So again, the Canadian government wants to make sure that the child isn't inadmissible for any reason, medically or a criminal or security issue. And so they'll insist on the applicant's passport having a medical examination completed if the child's over the age of 18, police clearances. So what we often see is that the uh, parent with custody back in the foreign country doesn't want to cooperate. Maybe they're nervous about the fact that the other parent may want to take the child away from them. Maybe the relationship is not on good terms, and so they don't want to cooperate and have the child medically examined. So this is a real stalemate for us in the immigration world, and we often have to recommend that our clients get family law assistance to figure out how they can have their child examined. If they still have shared custody, then maybe on a trip home they can figure out a medical examination. Um, but I've had an instance where my client did get a lawyer involved in the UK, and it just made matters worse. And so clients will push back. As immigration lawyers, we suggest that they document all their efforts, whether it's by email or social media or text, to reach out to the parent that is withholding the consent for the child to do the medical, and also efforts through family law counsel that may be communicating directly with the spouse abroad or the spouse's representation abroad. I had a case recently where the my client was from Australia. She had 2 children. She had the children in vitro from frozen embryos from her ex um, uh, spouse, and but they had divorced, but for whatever reason, the court order hadn't uh, given custody to her. She had just assumed that the children were hers. She had the consent from the father to use the frozen embryos, but he had never had any sort of interaction with the children. But she had put his name down on the children's birth certificate. So we were in the sort of difficult situation that we couldn't proceed with her application without that biological father's consent. And finally, we did get it, but it took a lot of work, and affidavits had to be sworn, and family law counsel had to be engaged. So those are 3 areas where family intersects with immigration in my practice. I'm going to just speak a little bit about criminality, and then I'm going to hand it over to Connie to speak more about criminality. So the starting point in terms of admissibility on grounds of criminality really turns to Section 36 of the IRPA. And they're under this section, an individual can be inadmissible for having been convicted of a criminal offense in Canada. So the key here is the word conviction, and keeping in mind that if someone has an absolute discharge or a conditional discharge, that's not treated as a conviction in Canada under the Criminal Records Act. So that would not be a problem. So if you have a client and you know they're not a Canadian citizen, um, and you need to, as criminal counsel, be considering what the outcome of the criminal matter will be and the implications on their immigration status. And a conviction could negatively impact that individual's immigration status. So it has to be an act of parliament. So if it happens to be a territorial or provincial legislation, like careless driving as an example, then that would not make the individual inadmissible under the immigration legislation. Similarly, if the individual is convicted under the Young Offenders Act, that would also not equate to a criminal conviction and make them inadmissible. Um, Also, under IRPA, if it's a pure summary offense, then that would also not make them inadmissible. I think there are approximately 18 at one point. I was doing work for a major retailer that was coming to set up in Canada. We did about 300 work permits over the course of a couple of years. And I think we had about 15% of those cases where the American had some issue in their background, and so at the time we looked at the legislation, and we identified, I think, about 18 circumstances of pure summary offenses. So the most common one is disorderly conduct. So that would not make the person inadmissible. But the tricky piece is if it's a hybrid offense and there's an election of to proceed summarily and a conviction summarily, that doesn't mean that they're not caught under the immigration legislation, because IRPA makes it very clear that a hybrid offense is treated as if it's an indictable offense, and therefore the person would be inadmissible. So um, before I hand it over to Connie, I'm just going to talk about the difference between what we call a serious criminality offense and a regular criminality offense under Section 36 of IRPA. So to be considered a serious criminality offense, you have to look at what the potential sentence under the Canadian Criminal Code is. And if it is at least 10 years, then it's considered to be a serious offense. So it's not the actual sentence that the person receives, it's the potential sentence under the legislation. And there are some really serious implications of being caught under a serious criminality offense as opposed to just a regular criminality offense. And I just want to before I hand it over, just give the example of driving under the influence. So under the criminal code, since December 18th of 2018, the potential sentence for driving under the influence has been increased, and it now includes incarceration of up to 10 years. So that makes it a serious criminality offense. The reason that the sentencing went up in December 2018 was because we legalized cannabis in Canada. And so in order to deter people from driving under the influence of marijuana, the government decided that they would increase the potential incarceration sentence. And that now has triggered it into a serious criminality. So the key, though, is when is the date of the commission, not the date of the immigration application or the conviction, but the Supreme Court in Tran versus Canada has said that it's the date of the commission that you look at to determine what the law was at that time and what the potential sentence was. So to finish the piece on criminality, I'll turn it over to Connie, and she can talk about what the implications are for persons that end up convicted of a serious criminality offense in Canada.
Thanks, BJ. And again, really nice to be talking to all you. I don't have the same long connection to the Northwest Territories, but I have spent some time in Yellowknife and really, really enjoyed my time there. So hope to get back up sometime soon. I would start by kind of echoing something Cheryl said about the core being always making sure you know your client's citizenship or immigration status. Just to highlight what BJ was saying about the difference between serious criminality and criminality is that criminality applies to all foreign nationals, including students, temporary foreign workers, and people without status in Canada, whereas serious criminality impacts permanent residents. So it can lead to the loss of status for somebody who's already landed as a resident here. So we're generally much more worried about serious criminality than criminality, but criminality simpliciter can still affect a lot of folks, especially very new immigrants. I know there's a number living in Yellowknife and in the territories now. So something to keep in mind. I should note, I really got to update my bio. I no longer practice in all areas of immigration law. I really just practice at the Immigration and Refugee Board and before the federal courts, and then every once in a while in the provincial superior courts on immigration related matters. And so anyone with questions about actually helping clients get status in Canada, generally go talk to BJ. And if you have clients who are at risk of losing their status, get in touch with me. So speaking to the effects of a finding of serious criminality against a permanent resident or temporary resident of Canada, generally referred to as a foreign national, the biggest concern you have is what rights do you have to sort of fight to maintain your status once there's been a conviction in Canada. You don't generally have a leg to stand on. The procedurally they'll drag your client through a hearing at the immigration division of the Immigration and Refugee Board, but it'll effectively be a 10-minute summary affair where they'll say, yes, there's been a conviction in Canada and you're losing your PR. Now, the question that you ask at that point is, does this person have a right of appeal? I'm just going to share my screen if this works. And the biggest concern for everyone is that there is no appeal for inadmissibility to the Immigration Appeal Division by a foreign national or their sponsor, or by a permanent resident if the foreign national or permanent resident has been found to be inadmissible on grounds of security, violating human or international rights, sanctions, serious criminality, or organized criminality. And that here they define serious criminality slightly differently than under 36 or section 36. It's very similar, but it looks only to the actual sentence imposed. That is, if it's a conviction in Canada that is under serious criminality under 36(1)(a), which is generally what most criminal law practitioners are going to be dealing with. So I'll mostly just talk about that. You need to have been sentenced to a term of imprisonment of at least 6 months. So 6 months or more. Under 36(1)(a), it's actually less than anything, less than 6 months is, there's an off by one issue in the drafting. Again, don't worry about it. There are very few cases where that's going to become an issue. But really you're looking to the imposed sentence, and that is a carceral sentence. Community sentence orders, suspended sentences, anything non-carceral doesn't count as 6 months. They're generally considered less serious, and there's case law to the effect that there's a recognition that what they're talking about here are carceral sentences. It is the ordered sentence and not the actual sentence served. So if somebody's getting credit for pretrial custody, and the sentence imposed, or the number of days actually spent physically in jail is less than 6 months, but the sentence imposed is more, you lose your appeal right on that imposed sentence. The reason you care about appeal rights is that, unlike at the Immigration Division, the Immigration Appeal Division has humanitarian and compassionate jurisdiction. That is, even if they recognize that you are seriously criminally inadmissible to Canada, you can ask for forgiveness based on a wide range of considerations, including your establishment in Canada, the hardship you might face if returned and having your life disrupted by removal, and the best interests of any children directly affected. Almost all the time, even if there's a positive resolution at the Immigration Appeal Division, they're going to put your client on a stay of removal. That is effectively an additional probationary period, often up to 2 years. Sometimes you can get them to keep it shorter, where you basically, if you, or you're bound to certain terms, generally including some generic terms such as keep the peace and be on good behavior, to not reoffend, to not have any new convictions under an act of parliament. Even charges can sometimes result in the revocation of a stay, depending on the circumstances. So even success on appeal often leaves your client in a fairly precarious position. Every once in a while, you win outright if the offense in question is relatively unserious, and if there are like other overwhelming humanitarian considerations, and that gets into a pretty specific factual analysis. I should also say that prior to all of these procedures at the board, I forgot that I had meant to talk about this, there's also a referral stage where, if you're a permanent resident of Canada, the Canada Border Services Agency will send you a letter saying, hey, we think that you're criminally inadmissible to Canada because you have a conviction that's under an indictable offense with a maximum punishment of at least 10 years. We're going to push you to an admissibility proceedings unless you can convince us that we shouldn't. Now, they don't have to consider humanitarian considerations at that stage, and where you have appeal rights, they generally don't make any other considerations. They'll really only consider the seriousness of the offense and whether there's some kind of rehabilitation or something else there. The case law on what they actually have to do on those kind of courtesy referral letters is pretty muddy. Basically, they can consider things like the best interest of a child, but they don't have to. If they do, they have to do it reasonably. So you kind of just have to convince them to bother looking at all of the factors you want to put in front of them. Crucially, where there's no appeal rights, either because your client served or was sentenced to more than 6 months of carceral sentence, or they face inadmissibility under one of these other heads: security, organized criminality, human rights abuses, which I'm going to get into in a second. That's where you want to make sure that at that referral stage, you're making the strongest submission possible. And I'd recommend that if you ever have if you're working in this area and you ever have a client who doesn't have appeal rights, to get in touch with immigration counsel as soon as possible, because you really want help. Your client's really going to need help from that very early stage, right after conviction, basically. And often they'll bring notice of inadmissibility even prior to a conviction, if they think that there's an issue of organized criminality or something else going on there. So definitely something to consider. All of this applies equally if there's a pending immigration application. If your client's in Canada on temporary status, has a spousal sponsorship pending, if there's criminal charges that come down during a family class sponsorship or a spouse or common law partner in Canada sponsorship, that application is going to be paused as soon as they learn about the charges, and they're going to wait, and often will send you what's called a procedural fairness letter saying, hey, we think that you might be inadmissible for criminality. We've heard about these pending charges. Please let us know how they resolve, and we're going to put your application on hold until then. Sometimes they just don't even tell you; they just shelve it, and you're just stuck waiting until the criminal charges resolve before you can move on with the sponsorship. Lastly, again, on just kind of general PR inadmissibility, not all PRs are created equal. If your client is a protected person in Canada, they're protected from removal even if they're found to be criminally inadmissible to Canada. Subject to an additional proceeding called a danger opinion. Again, if you have a client who won a refugee claim or resettled to Canada as a refugee and is facing allegations of criminal inadmissibility, make sure they talk to an immigration lawyer, because the danger opinion process is lengthy and really quite complicated. There's multiple rounds of submissions. You have different procedural rights at each stage. And it's important that you are making kind of the strongest possible submission at each stage of those danger opinions, because if you lose a danger opinion, you can be removed somewhere where your life is at risk or where you're at risk of persecution. So you're effectively, they're saying we're removing you despite the acknowledgement that your Section 7 rights are imperiled by this removal. Doesn't happen all that often, but our office is fighting one right now, and somebody's kind of at risk of removal to a very, very dangerous situation because of their criminal conduct in Canada. And that's really kind of the highest stakes that this job provides. Speaking of stakes, moving quickly, I just want to cover one thing that's been happening a lot more lately. So here's the criminal inadmissibility or serious criminality. Down below at Section 37 is organized criminality. In a number of cases that our firm has seen lately, CVSA is alleging somebody who was either convicted or in many cases not convicted of criminal offenses that are not criminally inadmissible to Canada, or were sentenced at a level where they would maintain appeal rights. They're not even bothering to bring criminal inadmissibility charges because they know this person's going to win eventually, at least a stay of removal. So if there's evidence to suggest that there was more than 2 other people involved in the offending, they'll try to call your client a gangster and bring inadmissibility allegations for organized criminality. There is case law to say that this provision, Section 37, needs to be interpreted in line with the criminal code definition of organized criminality. And so it's 3 or more people conspiring to commit an indictable offense. Our firm is really pushing for some of the newer commentary on Section 37 that it's meant, or sorry, not Section 37, on the criminal code organized crim definitions, that it applies only to organizations that pose an elevated risk to society, or that it's all meant to capture organizations that pose an elevated risk to society, be brought in more seriously into the immigration context, because they are throwing these allegations around for what I consider to be, or what in my opinion and in our position is often, that these are common intention offenses. These are conspiracies. These are one-off events. They're not ongoing patterns of criminal offending, and they're not gangs in the traditional sense. They are a group of people who came together to commit some kind of a crime, but they are not an organization that poses an elevated risk to society. They're not meant to be captured by these very serious provisions. Part of that is some recent development. Part of that argument is some recent development in the jurisprudence of the Supreme Court on all kind of elevated inadmissibility provisions, that is security, organized criminality, human rights abuses, which can allow for individuals to be refilled to persecution despite either winning a refugee claim or having made a claim for refugee protection. So the fact that these provisions, not serious criminality, but the other three heads of more serious inadmissibility to Canada, exposes somebody to this risk of persecution, means that the definitions need to be really hammered out a bit more squarely than they have been in the past. And there's a lot of earlier jurisprudence that just suggests that all of these things are meant to be interpreted very broadly, and then it all comes down to CVSA discretion and back-end applications for relief from the minister. But the Supreme Court seems to be pushing things in the other direction, and hopefully we get a couple good decisions in that area from the Federal Court of Appeal in a couple upcoming cases. So if your clients are facing any of these, and increasingly it is happening for individuals from Iran, Bangladesh, a number of other countries are getting a lot of these sorts of allegations brought against them. And then again, anybody who's involved in sort of multi-party offenses is getting hit with organized criminality. Please get in touch with somebody experienced in the area, because it's developing really quickly, and it's really quite complicated. So, and again, the stakes are extremely high. But I'll end my presentation there, because I'm sure there might be a couple of questions.
Does anyone have any questions? You can either go on camera or raise your hand or write in the chat. Okay, well, maybe I have one question just to start us off. And again, thank you so much for presenting today. That was very fascinating and very helpful. Maybe from Connie and BJ, if there's an ongoing case, what maybe are some takeaways for criminal lawyers to keep in mind, maybe in their negotiations with Crown Counsel, when there hasn't been a conviction yet?
Well, I think what Connie and Cheryl said about knowing your client. And I think part of the times too, we're trained not to sort of differentiate on nationality and race, but you need to know what your client's immigration status is. So if they're not a Canadian citizen, then you have to be thinking about the immigration implications. So that would be my number one recommendation. And then always, to the extent that you can, you want it to end without a conviction. So, either tried as a young offender, so it doesn't end up as an equating as a conviction, or an absolute discharge or a conditional discharge, or plead to a lesser offense that is a pure summary offense. So those are your first steps. Anything else, then you really should probably be checking in with immigration counsel if the individual has counsel. So those would be the number one things. I don't know, Connie, can you think of some others?
Yeah, the other one is things like agreed statement of facts, which aren't very common in things that are seen as sort of very low level offenses that are still hybrid offenses. Because often at sentencing, a lot of things will be said about what happened that then get used for like in somebody's immigration appeal, even to talk about how serious the conduct was or not. So both in terms of thinking about parties to offenses potentially leading to an allegation of organized criminality, or really just base statements of facts about the severity of the conduct that's actually being pled to. So making really clear what conduct your client is pleading to can be really important. And you probably want to talk to an immigration lawyer about why and exactly what circumstances that would be relevant, but it ends up being very important. And usually by the time I'm working on a file, all of that's already written in stone and very difficult to undo.
Yeah, no, that's I'd forgotten, because there was a time when I did do litigation and appeal work, and I had a client once. He was married to a Canadian citizen, and he'd been convicted of trafficking drugs, and in the sentencing, there was evidence that he was a drug user, and so on the appeal, on the immigration appeal, I was hammering home, well, where's your evidence of rehabilitation from this drug use that is referenced in the sentencing? And he wasn't handing anything over. I'm like, well, you must have done some counseling or whatnot. Well, finally, he confessed that he was never a drug user. He was just a drug trafficker, but he had claimed that he was a drug user so that he could get a lesser criminal sentence, that would be taken into account as a mitigating factor in sentencing. So I had to get off the record because I couldn't put him in the hearing box and ask him about that. So that was very early on in my career, but yeah, what goes on in the criminal courtroom and the transcript could end up in the immigration hearing. It's a really valid point.
Wonderful. Well, that was a great answer. Explained it for me anyways. And thank you again so much. I think we've reached the end of our time here, but this will be recorded. So there'll be a link for anybody who wants to review it, or the people who can make it today. And also Cheryl's presentation will be circulated as well. So Cheryl, you can flip that to me. Thanks again so much. Have a great day.
Thanks, all.
Happy weekend. Happy Mother's Day to those celebrating.